an appeal in the matter of Lufthansa Technik AG, Astronics and Electronic Systems and another.
Yes, Mr. Cardigan.
May it please my lords, this appeal I've here from Lufthansa with my own friends Mr. Hall and Mr. Walmsley, Mr. Purvis, Dr. Appellant and Mr. Copeland representing the defendants, who I will call Astronics, save where I need to distinguish. Subject to my lords, I will be presenting our first 3 grounds of appeal, with Mr. Hall addressing you on ground 4, apportionment. Mr. Hall will then respond to my learned friends on kid apportionment. I will respond on double recovery, and Mr. Walmsley will respond on the interest appeal.
Right.
The ground 1 appeal concerns the correct conceptual approach to isolating profits derived from patent infringement. The authorities point in 2 different directions. The first accords with the modern analysis of factual and legal causation in damages, and with the approach taken by Lord Legate in a couple of judgments of the Supreme Court. The second reflects an older approach associated with the rule in United Horseshoe, as exemplified by the Celanese and BP decision of Mr. Justice Ladd. In the judgment under appeal, the learned judge sought to combine both approaches. In our submission, the 2 approaches are not economically compatible. They are alternative ways of answering the same question, and the approach taken by the judge involves applying both of them sequentially, what we have called a double deduction. If I could start with some definitions, I'm going to call that first approach differential profits. And differential profits has 2 steps: factual causation and legal causation. The factual causation step involves a but-for counterfactual, a comparison between the real world and the notional non-breach world. And for the purposes of that comparison, the infringer is permitted to assert and prove a non-infringing alternative course of action. If successful, they can rely on any profits which they would have accrued in pursuing that alternative course. The purpose and effect of this comparison as against real-world profit is to isolate the profit derived from the use of the invention. The non-infringing alternative, or NIA, operates as a control experiment. The court is given 2 data points. The only distinction between them is the presence of infringing activity, so the profit differential can be economically and legally attributed to the infringing acts. Step 2 is legal causation, and it has the same role and effect as legal causation in damages. As to the second approach, in the account of profits authorities, that is called apportionment. That is an ambiguous word in this context because differential profits is a species of apportionment. And so instead I will seek to use the word allocation. This approach involves a broad allocation by reference to some external factor. In the Celanese case, the profits were allocated by reference to the capital cost of infringing as opposed to non-infringing processes. There is a problem with this sort of cost allocation. The unspoken premise is that the value of the invention corresponds to the cost of putting it into effect. And that premise is unsound as a matter of generality, and indeed in Celanese itself, no basis for it was given. And that problem can be readily demonstrated by reference to a simplifying invention. You could have an invention which bestows a huge benefit by allowing for the removal of a costly manufacturing step, and it would be allocated 0 profits. In Celanese itself, Mr. Justice Laddie was presented with differential profits and allocation as alternative approaches to the isolation of profits. He felt obliged to reject the former and choose the latter in light of the rule in the United Horseshoe case. That rule prohibits an infringer from asserting a non-infringing alternative as part of their defence to a damages inquiry, and in Celanese, Mr. Justice Laddie extended the rule to accounts of profits. If NIAs are impermissible, then differential profits is impermissible. It is not our position that the law should never permit an allocation approach. We say that the Supreme Court in Canada was right to say that differential profits is the preferred approach. But we are definitive in saying you can't do both. The judge's double deduction was wrong in principle. It was common ground at the trial that Celanese was wrongly decided and that the judge should conduct a differential profits analysis. And we say that having done so, there was no room for the broad allocation with which he followed it. Now, that is our first round of appeal in a nutshell. Before developing it further by reference to the authorities and the judgment, there are two aspects of scene setting. The first is general, it relates to causation and patent and the value of patent rights. And the second is specific, the facts of this case and some of the procedural background. That factual background matters because it explains why, on the facts, Lufthansa's patent controlled this market, at least as far as Astronics was concerned. And that point helps to understand our position across the whole appeal. So, NIAs and the value of patent rights. As the court is aware, a patent confers a negative monopoly. It gives the right to exclude others from carrying out certain acts in relation to an invention. It is a conduct-based monopoly. The infringement provisions...
What do you mean by conduct-based?
What I mean...
As distinct from what?
As distinct... So it's not the infringement provisions of the Act bite exclusively on activity, on infringing acts, as opposed to something more nebulous like the use of an invention or benefiting from an invention. Because it is a conduct-based monopoly, its commercial value is determined by the size of the market for that conduct. The market is determined by the boundaries of the patent, and they are set by what needs to be done to avoid claims. The acts which fall inside and outside the monopoly set the boundary. So if one considers a valid patent for a motor vehicle, which is limited to cars painted pink, one can avoid the claims by making and selling cars in any other colour. Pink cars are in relatively low demand, so taking that course involves little economic inconvenience. The market controlled by that patent is of low value. If the patent was limited to monochrome cars, it could be avoided by using coloured paint. The market controlled by that patent is more valuable. If the patent extends to all four-wheel vehicles, it becomes extremely valuable. To avoid it, you need a motorcycle or a Reliant Robin. That analysis feeds into the foundation of our case on appeal. Where there is no commercially viable, non-infringing alternative, the patent controls access to the whole market. That is not a matter of submission, it is a legal consequence of the statutory right. Third parties cannot reach customers without committing infringing acts. Where a particular third party has no commercially viable NIA, the value of the patent to them is equal to the value of that market to them. The patent is a gateway to all economic operation. In the present case, the judge held that Astronics had no commercially viable NIA. If they had observed the conduct-based monopoly granted to Lufthansa, they could not have made any of the power supply sales in issue.
Can I put an analogy to you? It's quite common in the development of land for somebody to have a small piece of land, which is what they call a ransom strip.
Yes.
Without the land, you can't make a profit out of developing the site next door. And in that context, it's very common for an award to be made, which is not the whole value of the profit made by the development, but a proportion of it, to reflect the value of the ransom strip. Now, is that very different from your submission that without infringing the patent, you can't get access to the market?
Yeah, so the difference is that with the ransom strip, there is an intention to develop something else. You want to go through the land to get access to somewhere else. What's different here is that my strip of land is the market. So I'm not using the patent to control something else. Astronics came and played on my strip of land, and all their profits came from that. They were accrued but by using infringing acts. So there isn't that distinction between another market which is being controlled. This was the market. As a result, we say that when the judge made an allocation of the profits of these sales, he failed to give effect to the statutory monopoly. He replaced the monopoly with a court-constructed licensing scheme. He substituted Lufthansa's right to exclude conduct with a right to reasonable remuneration. Where does legal causation fit in? Well, in damages, the objective is to put the claimant back in their non-breach, non-damaged position. To that end, the court asks what losses did the claimant suffer as a result of the defendant's acts of breach, and orders payment of those sums in compensation. The account of profits is concerned with the obverse question: what gains did the defendant obtain by carrying out acts of breach? Once you've answered that question, by ordering the defendants to account for those gains, the objective of the remedy has been achieved. In the words of Lord Leggett in Lifestyle Equities, you have put the infringer back in the same position financially as if no infringement had taken place. All that remains in respect of both remedies is the legal causation rider. The rider necessarily risks incomplete restoration. Where it applies, the rights holder sustains some infringing damage, and the infringer keeps some of their infringing profits. The rider exists because there are circumstances where complete restoration conflicts with the reason why the tort in question exists. So for patents, the rider applies where any type of profit or loss is so remote from the infringing act as to be in substance disconnected from it. There's a good example of the application of the legal causation rider in the Lufthansa case, which we will be coming to. The defendants used some of their ill-gotten gains to make investments, and the profits on those investments were not accountable. They were deemed too remote from the defendants' breaches of fiduciary duty. So the order issued by the court did not put them back in their non-breach position. They retained those investment profits. It is our position that causal issues, such as legal causation remoteness, are by their nature binary. The law is concerned with chains of causation, whether particular financial consequences are or are not causally linked to acts of breach, and chains of causation hold until they break. We say that legal causation remoteness is not a principle which permits the court to dilute recovery based on notions of fairness or value. So in Anand, Kasai and Neo, the court did not have discretion to award Rhodia 50% of its losses because they were a bit too remote. That's not how causation works. We say for either damages or profits. Moving on to my introduction on the facts. My lords will have seen that Astronics seek to portray the failure of their NIA case as some sort of procedural anomaly. We say it's no such thing. It properly reflected the true factual position. This was a new and valuable market created and controlled by Lufthansa's invention, and Astronics had no way into that market without infringing. I want to demonstrate that by reference to the findings in the judgment, which is in the confidential bundle. We could invite my lords to start at page 13 of the judgment, paragraph 19. This considers a draft memo issued by the Federal Aviation Administration in June 1996. This is the world before the patent, whose priority date is May 97. You'll see the memo quoted under paragraph 18, and if you turn over the page to see criterion 4 and 5, the memo proposed that in-seat power supply system voltages could not exceed 24 volts, so a low voltage system. It was safe because it was low voltage. And on the 3rd of October 1996, the FAA published the official guidance. And in addition, you can see from the text of paragraph 20, this required, just at the end of that paragraph, this required the power supply to have a DC outlet only. Now, Astronics, which was called Olin at this time, had launched a 15-volt DC power supply in February of 1996, and that product had been successful. If you turn back to paragraph 15 of the judgment, please. It was successful, but it had what the judge called, in the penultimate sentence, a disadvantage. It required a special adapter and charging cable. And the judge called this a disadvantage because passengers would much rather have just plugged in like they could at home. But mains voltage was dangerous, so it would have to be made very safe for use on an aircraft at 30,000 feet. Lufthansa invented and patented its safe mains socket arrangement, and in December 1998 it entered into an agreement with KID to bring it to market. That's the 1998 teaming agreement, which is the subject of my learned friend's appeal on KID apportionment. If you turn forward, please, to page 25 and paragraph 41, we can see that by April 1999, Astronics, now called Primex, had heard about the KID AC product, and it had caused serious disquiet. The judge records in the second sentence that Astronics' business development manager, Mr. Brisky, attempted to discourage Mr. Busey of the CAA from recommending the adoption of AC power. The KID product was, of course, a serious threat to Astronics' DC product. Astronics understood that passengers wouldn't be interested in their DC system if a convenient AC system was available. And at paragraph 42, the judge records that Mr. Green, the marketing manager of Astronics, called a meeting to refine their strategy to anticipate KID's actions and to deal with their success in obtaining certification of AC power. And then we can see an extract from an internal email between Mr. Green and Mr. Brisky, which is quoted. Can you read that, please? Airlines were anxiously waiting for this news. It was not a pretty picture for Astronics. Their response was to lobby the regulatory authorities. You'll see it, paragraph 43. Only a few days later, on the 5th of May, I'm in the second sentence, 1999, Mr. Brisky is writing to Boeing enlisting their support in trying to persuade the UK and European authorities not to adapt their guidance to permit AC systems. And then in 44, there was a meeting of the JAA at which the issue of voltage was discussed. Mr. Brisky presented Astronics' case for low voltage DC power. And if you turn forward, please, to page 217 of the judgment. At the same meeting, there was a presentation by Kidd. Could you please read? Yes. Could you please read paragraph 371? So Astronics lost this battle. Kidd's presentation of the inventive power supply was instrumental in the JAA accepting high voltage AC power systems. That was the outcome that they feared and had lobbied against. Back then, please, to page 34. And paragraph 57. Kidd launched its AC Sky Power system in April 2000, and the response by Astronics is recorded in paragraph 60. Astronics had to enter what the judge calls in the middle of that paragraph a rapid development program to get an AC product to market. It's obvious why they needed to do this. Customers wanted an AC power system, and now that Kidd's product was available, interest in Astronics' inconvenient DC system was going to flatline, and the judge made factual findings to that end. We have to turn forward now to page 229. Paragraph 400. Could you please read the first 3 sentences down to offer to its customers? Mr. Market and Mr. Duper were Astronics witnesses. And if you turn forward then, please, to page 232, paragraph 4013. Once it had become available, the judge records, customers expected AC power. Astronics needed an AC power product to be in the market at all. That is indicative of the DC products becoming obsolete. Now, once Astronics got through its urgent development program and launched the AC M-Power system, it was much more successful than the Kidd product. Astronics was better at exploiting the invention of the patent than Kidd. But the power supply business over the relevant period was based exclusively on the AC system. So that was what was happening on the market, and Lufthansa's case in the account reflected these facts from the outset. We pleaded I'm quoting from the points of claim, you don't need to turn them up, I don't think. The relevant market was at all material times for systems which provided AC mains voltage power in an aircraft cabin through sockets suitable for conventional plugs. We said that the key technical barrier to entry into that market was conceiving a power supply design which was sufficiently safe and robust to be certified and approved. Lufthansa's intention was always to argue for differential profits, and it wanted to ensure that any positive NIA case which Astronics relied on was properly pleaded as a counterfactual, a factual assertion of what they would have done, and that such a case would be accompanied by disclosure and evidence. It was not clear to us from their pleading that they were approaching the NIA issue on the right footing. So we raised the issue at a CMC before Sir Anthony Mann in July 2023. We explained our position, our legal position on differential profits. We explained the critical role of the non-infringing alternative in that scheme, and we sought an order for a formal pleading if it was Astronics' intention to rely on a positive NIA. I say a positive NIA because an infringer always has an NIA available. It's the counterfactual where they don't trade and don't make any infringing supplies. Sir Anthony Mann accepted our argument and ordered Astronics to plead any NIA case which they wished to run, and they served a statement of case in relation to alternative products on the 2nd of August 2023. They identified a single such product, a notional modified version of their mPower systems called the 1171M. So the real product was 1171, this was the notional 1171M. And those are the notional products that are referred to in the long NIA section, the infringement section of the judgment. It was Astronics' case that the modifications would have cost a few $100,000 to develop and would have resulted in an additional cost of $50 per unit. They said that the 1171M would have enjoyed identical sales to the real-world 1171 system, and their accountancy expert calculated the difference in profit to be $23,000 for Astronics and $0 for Panasonic. So on a differential profits analysis, if the NIA case succeeded, Lufthansa's profits claim was all but extinguished. And it was with that alluring prize in view that Astronics chose to tell Mr. Justice Leach that differential profits was a principled approach to causation. Indeed, they said in terms in their amended points of defence that an appropriate measure of the profits to which Lufthansa was entitled was the differential as between actual sales and sales of the hypothetical modified 1171M. For my Lord's notes, that's core tab 26, page 404, paragraph 28A. Now, they could have run a non-infringing alternative case based on the USB product that is also mentioned in the points of defence, or the DC product which Mr. Brisky was so desperate to protect. Those were both viable, technically viable, non-infringing options. But as we saw from the documents and was confirmed in the oral evidence, they were not commercial substitutes on the facts. Astronics witnesses knew that the market we are concerned with was AC power or nothing. This is in effect the market for business class seats, and once it had been introduced by KID, AC power quickly became a non-negotiable. If Astronics didn't have it, they'd lose the sales to KID. In their skeleton reply, my learned friends say, this is paragraphs 50, page 81 of the core bundle. They say if they hadn't raised the NIA issue, they would have been entitled to ask for an apportionment, by which they mean allocation, in the usual way. My lords, they didn't raise the issue, we did. We told them our case theory about differential profits, we presented it to the court, and we obtained a court order that they plead out any NIA case which they wanted to assert. They saw the possibility of huge advantage, and they pleaded in terms that this was a principled approach to profit isolation. And then they accepted our argument on the law before the judge. They told him in terms that the Celanese case, to which we will come, was wrongly decided, and that the rule in United Horseshoe should not be followed. And to be clear, we accept that Astronics were at liberty not to engage with differential profits. They could have asserted no NIA at all. But that would have been risky, because the court might have decided that it was the principled way to proceed, which of course is exactly what the judge did decide. Could you remind yourselves, please, of paragraph 325 of the judgment?
That goes further than the submission you are now making, isn't it? The judge says the differential profits approach should be adopted to every account of profits, and you're not going that far.
My lord is right, I'm not going that far. I say it's the preferred approach, but the judge was convinced that it was the only approach.
So you don't support this paragraph?
This is recalling a matter that was not in dispute before the judge in first instance. But we do not invite this court to say that differential profits is the only approach that can be taken, because there may be facts where it simply can't be done.
Or it's not necessary. I mean, if I patent a widget,
yes,
and somebody sells a widget which infringes my patent, all I need to do is count the number of widgets they've sold and take the profit. I don't need to look at anything else, do I?
Well, my lord, we say that is differential profits. It's just that there's no counterfactual. There's no non-infringing alternative where you can say, well, I don't want to take it too far out, of course, but it depends on the market for the widget. It's not simply a question of looking at the patent and the infringement. You need to see the commercial context in which this is taking place. If there are all sorts of other widgets, if you have a production line with widget A and widget B on it, and customers are completely indifferent to which widget they buy, and widget B infringes, it is appropriate, according to the differential profits theory, for a defendant to say, well, I would have sold a lot more of widget A if I couldn't have done that. Now, the court can say, on the facts we don't agree, but in that way, the contribution of the patent is properly isolated, it's properly valued. If it's not actually protecting a market because people are completely indifferent to its benefits, then the profits should not be accountable. That is the attraction of the differential profits approach. It focuses on the value of the patent. Two things I just want to pick up that my learned friends say in response on this approach. They say that cautious defendants would plead backup NIAs. Sorry, one thing I want to have. I have two points to make in relation to that. There are two constraints. First, a counterfactual course of action has to be proved on the balance of probabilities. Pleading multiple alternatives would be liable to be counterproductive. They would likely all fail to meet the civil standard. So to assert that I would have done A or B or C would prove tactically incoherent. And second, because counterfactuals are dealt with in our courts as issues of fact, they are dependent on witness evidence. In this case, Mr. Duper gave sworn evidence as to the course Astronics would have taken back in 2011 if they had resolved to avoid the Lufthansa patent. His evidence was that they would have produced the 1171M product. Well, this submission suggests that Mr. Duper was free to make up different facts in that regard. We do not agree. My lords, those were my introductory submissions, and I'm coming on to grapple with ground one in earnest now. As I've said, the judge carried out a differential profits analysis and followed it with a broad Celanese style allocation. We say that would only be justified if the first stage, differential profits, does not act to isolate the profits derived from the infringement. The first part of our argument therefore involves a review of the role of and rationale for differential profits, which emerges consistently from authorities in different jurisdictions over many years. And we can start briefly, please, back in 1871 in the US Supreme Court, for which you will need bundle 4, JA bundle 4, tab 91. This is the case of Mowry and Whitney. And I'm going to take it from the account from Professor Seabrass's seminal article. This is the article which was quoted with approval in the Canadian Supreme Court when differential profits was first approved at that level. Could you turn please to page 3061? And could you first read to yourselves the sidelined passages on page 3061 and 3062? This is addressing the same issue which is before this court, how to isolate profits derived from the infringement. In Mowry and Whitney, the patent was for an improvement in the method of manufacture of railway car wheels. And
So you've just referred to
yes,
Mowry.
yes. So if you turn forward, please, to 3063. I should have taken you forward first. And the defendant Whitney used the patented method as one stage in a multi-stage manufacturing process. So instead of a complex product, it was a complex process. And the question arose how the profits should be awarded to reflect the various profit drivers in the sale of the wheels. In the paragraph 221, Professor Seabrass says, the law in the United States is very clear. Apportionment is based on what is conveniently termed a differential profits approach. And the quote from Mowry and Whitney, the question to be determined in this case is, what advantage did the defendant derive from using the complainant's invention over what he had been using, over what he had in using other processes then open to the public and adequate to enable him to obtain an equally beneficial result? And that rule subsequently confirmed many times. Note the reference to apportionment there as being based on the differential profit approach, because this is a method of apportionment.
But Professor Seabrass seems to contemplate looking at what is the highest price that a licensee would be willing to offer for the right to use the patent. That's page 3064.
3064?
Yeah.
Yes, so the two will coincide, because when you use the differential profits approach, you are estimating the value of the patent on the market, as we shall see. So the first United Kingdom case is Siddell and Vickers. We can put JA4 away and go please to JA1. This was a patent action, JA1 tab 9 please. Patent action relating to a mechanism for turning large ingots. And the defendant had used a manual method before adopting the infringing method. So JA1 tab 9, page 82. But if you could turn forward please to 86. So they had a manual method, then they started using the infringing method, and after they were injuncted, they used an alternative method involving a snickle chain. And there was a dispute as to whether profits should be measured as against the prior manual method or the snickle method. And you can see at line 27 on page 86 of the bundle, the defendants relied on Mowry and Whitney in support of the snickle chain counterfactual.
Sorry, page 86 line?
Page 86 of the bundle,
Oh,
line
yes,
27.
yes, yeah.
And then we can pick it up, please, at page 92 of the bundle. This is in the claimant's argument at line 5. The snickle arrangement was really suggested by the plaintiff's arrangement and would not have been thought of without it. The defendants fell back on manual labour after each experiment. Therefore, the inference is that they would have gone on using it but for the plaintiff's invention. The onus is on them to displace this inference, and the only safe test of comparison is with what they were actually using. And at this point, the court states the true test of comparison seems to be with what the defendants were likely to use, looking at all the circumstances of the case. We say that is a differential profits assessment. The court compares real-world profits with NIA profits and awards the difference. That is obviously a very brief encapsulation of the principle, but there is further interpretation of Siddell and Vickers, as we shall see.
That's an observation in the course of argument.
Yes,
Is
it
there
is.
anything actually in the judgment?
So the judgment, no, there's nothing more than that. And indeed, in Celanese, Mr. Justice Laddie reviewed Siddell and Vickers and thought it was pretty ambiguous on this point. The reason I've taken it to you is because others have taken a different view, and there's now a weight of authority at the highest level in relation to that.
The litigation is enormous, the expense is great, and the time consumed is out of all proportion to the advantage ultimately gained.
My lord has stumbled on a passage, not stumbled, alighted upon a passage. Which
Well, I
has
read
been-
the judgment rather than the argument.
which has been quoted with some regularity about the difficulty.
And I think Lord Lindley knew more about accounts than most judges.
If we could go back to JA4, I apologise for all the jumping around, but we are taking it in chronological order, and the international authorities are at the back. So our next stop is Australia, and at JA479 we have Holbein Palmer, which is a trademark case, and the defendant sold painting sets under the name Craftmaster. The claimant had a trademark for Craftmaster, and they won their infringement action and sought the defendant's net profits from sale of the painting sets. If we could turn please to 2468. The defendant says you're only entitled to the profit caused by the use of the trademark. Mr. Justice Windayer agreed. And if you could start, please, by reading the passage at the top of 2468 down to line 13, selling it under the trademark. That passage was referred to with approval by Lord Legate in the lifestyle equities case. I invite you to note the disciplined and correct reliance on infringing acts. For the patent example, the sale of an article is said to be an infringement of the patentee's monopoly in the right to, quote, make, use, exercise and vend the invention. That's a quote from section 69 of the 1952 Australian Patents Act, which is at tab 3 of Bundle 1 of the authorities.
Yes, but the factual premise is that the infringer sells an article made wholly in accordance with the invention. Not he sells a complex product into which the invention is incorporated.
Well, yes, at this stage, my lord, yes. Could you move forward then to 2471? Line 19. What the defendant must account for is what it made by its wrongful use of the plaintiff's property. The plaintiff's property is in the mark, not in the painting sets.
Sorry, where are you?
Sorry, at line 19.
19, yes.
The true rule, I consider, is that a person who wrongly uses another man's industrial property, patent, copyright, trademark, is accountable for any profits which he makes which are attributable to his use of the property, which was not his. An early form of the order is in the patent cases for an account of profits actually made by the defendant by means of the infringement. Now, could you note in passing at line 48 the reference to Cartier and Carlyle?
Sorry, which line?
Sorry, line 38. Thank you. And then over the page, at page 2472 of the bundle,
He seems to approve of what Lord Kinnear said. Where part of a complex machine is protected by a patent, the infringer cannot be made liable for the aggregate profit.
Indeed, and as we will see how this plays out in the principles which are adopted. The paragraph that starts, if one man makes a profit, could you read that to yourselves, please, down to the Peter Pan, reference to Peter Pan? And then on page 2473, the judge says this: it's generally recognised in America that in the application of apportionment principles, mathematical precision is impossible. A reasonable approximation may suffice. It seems to me that a useful working rule may be derived from a means of ascertaining profit adopted in patent cases. In Frost on patents, this is put on the authority of Siddell and Vickers. The true test of comparison is to take the ratio of profit derived when the invention was used to the profit which would have been derived had the defendant used that which, looking at all the circumstances of the case, he would most probably have used had he not illegally adopted the invention. Substituting trademark for invention in this passage can be applied in this case. We say there are three propositions which can be taken from Colbean. First, the court adopts the differential profits approach. Second, in taking that course, the judge relies, indirectly at least, on Siddell and Vickers. And third, differential profits is explained as a species of apportionment. The court used differential profits in order to isolate the profits which were attributable to the acts of infringement, as distinct from those which were not so attributable. And I'm afraid we're back in JA1. This might be the end of the yo-yoing. Tab 22. My Kind of Town and Sol. Another case approved by Lord Legate. This was a passing off case. And it was established at trial that the defendant's use of the name Chicago Pizza Company had resulted in confusion amongst a substantial number of members of the public. The claimant elected for profits and sought an award of all the defendant's restaurant's profits. The defendant said they ought only to account in relation to the confused customers. Profits from customers who would have been there whatever name the defendants had used were not profits caused by their tortious acts. If we could go please to page 448 at line 3, Mr. Justice Slade says, as I understand the relevant principle, the object of ordering account in cases such as the present is to deprive the defendants of the profits which they have improperly made by wrongful acts committed in breach of the plaintiff's rights, and to transfer such profits to plaintiffs. We say that is the objective in the present case too, and note again please the accurate reference to wrongful acts. And Mr. Justice Slade reviewed a host of cases, one of which was Cartier and Carlisle at 453. Cartier is another trademark profits case. The goods were embroidery cotton and the labels were held to infringe a trademark. The judge here considers the decision of Sir John Romilly at line 23. Sir John stated, "I do not propose in taking the accounting chambers to make the defendant's account for every species of profit during the last 6 years, but I shall consider how much of the profits are properly attributable to the user of the plaintiff's trademark." And Mr. Justice Slade continues, "It appears that Sir John Romilly regarded the relevant comparison on account as being between 1. The profits which the defendants would have made on the sales over the past 6 years without user of the plaintiff's trademark, and the profits which they did in fact make. The defendants were to be accountable for the difference." So the counterfactual is a notional trade over 6 years in which the plaintiff's trademark is not used. My lords, that is an NIA. They are permitted to assert as their counterfactual an NIA in diminishing the profits award. They can rely on their counterfactual non-infringing profits, a paradigm differential profits analysis. Then over the page at 454, there's a reference at line 5 to Siddell and Vickers as being an instance where the court made an order directing apportionment of the defendant's profits so as to ascertain those profits attributable to the use of the plaintiff's invention. So there we are told that differential profits is a species of apportionment which ascertains the profits properly attributable to the use of the invention. That is precisely Astronics' defence of the allocation of 13% applied by the judge in this case. They say there's a gap which an allocation is needed to fill. And we say there is no gap. They are defending the use of 2 sequential profit isolation stages. And then at 456, we see that Mr. Justice Spade follows the Cartier and Carlyle approach. He says at line 17, on the actual taking of the account which I propose to order, the proper comparison will, in my judgment, fall to be one between 1, the profits actually made by the defendant's business, down to the date when they stopped using L.S. Grant's Chicago Pizza Company, and the profits which would have been made by that business if that name or any other name, including Chicago Pizza, had not been used. But they're entitled to put forward a different name, L.S. Grant's Delicious Pizza Parlor, as long as it doesn't include Chicago Pizza. That is a counterfactual NIA. They can posit an alternative non-infringing course of action and rely as a deduction on the associated profits. My lords, the next stop is Lifestyle Equities, which is in the third authorities bundle behind tab 76, penultimate tab. This is another trademark case.
I'm sorry, I'm behind you, Mr. Cuddy. On what, which?
Bundle 3, tab 76. So there were two issues in lifestyle equities. One was about directors' liability, and the other is about accounts of profits. And we say that Lord Legate endorses differential profits as a method for isolating profits derived from infringing acts. But he actually goes further than that, and he interprets some of the cases we've been looking at as supporting differential profits. And that's particularly important because in the Celanese case, which we will come on to, Mr. Justice Laddie had reached the opposite conclusion. Mr. Justice Laddie held that neither Siddell and Vickers nor My Kind of Town supported a differential profits approach. So Lord Legate gave the sole judgment, and the judgment on account of profits begins at page 2343. And at paragraph 145, Lord Legate records that an account of profits is a well-established remedy for infringement of intellectual property rights. And it's clear from the cases referred to in the discussion that this judgment is generally applicable to accounts of profits for infringement of IP rights. If we can pick it up, please, over the page 2345 and paragraph 155 at the bottom. Lord Legate states that a central purpose of intellectual property rights is to encourage and reward creativity and innovation by enabling the owner of the right to enjoy the fruits of its exploitation. That purpose is promoted by allocating profits made from exploiting the right to the owner. That language, made from exploiting the right, is the language of causation. It's concerned with isolating the profits derived from exploiting the right. And he goes on over the page. This explains why, in the words of Lord Justice Kitchen in Hollister and Medicostomy, the infringer is treated as if he has conducted the infringing business on behalf of the claimant. Then at 156, we have the language about putting the infringer back in the same position financially as if no infringement had taken place. Both sides on this appeal rely on this as being the objective of an account of profits. And then the differential profits reasoning starts at 2349, paragraph 170. Note, please, that this is still the ratio of the judgment, because in paragraph 180, Lord Legate says there are two sufficient reasons for diminishing or dismissing the appeal. And the second reason is that on the facts found by the judge, the Armeds made no profits from the company's infringement. Could you please read paragraphs 170 and 171 down to profit for the borrower, 5 lines into 171. That last sentence, very important. This difference might generate a profit for the borrower.
Sorry, where are we?
Sorry, my lord. So we're 2349, paragraphs 170 and 171.
Yeah.
If the loan is interest-free or at a rate of interest lower than a commercial rate, this difference might generate a profit for the borrower. I'm saying that in the context of an account of profits.
Yes, I see.
What he's saying, we suggest, is that to identify a relevant profit, one compares the terms of a commercial loan with those of the loan made available by infringing behaviour. In other words, a comparison with a non-infringing alternative loan at a commercial rate.
I'm sorry, I'm struggling to understand that submission. The loan had nothing to do with the infringement. The infringement was trademark infringement.
Yes.
It so happened that Mr. Arnold made a loan to the company. The question is, what impact did that have on the profits?
Indeed.
There was no question of the loan being an infringement.
What Lord Legate is saying here is that the loan might constitute a relevant profit if it is if the infringement gave rise to the loan, the infringement made the loan possible, and the loan was at a beneficial rate. So the course is trademark infringement activity generates some income.
I'm sorry, I'm struggling. Maybe I'm missing something here. At the moment, this seems to me to be directed to a prior question. Is there a profit at all? Indeed, because at first instance they said you got a director's loan out of this, that's profit. And what Lord Legate is saying, that's not enough. You have to do more.
You have to
show that there is a profit at all.
Yes.
Before you come on to any question of is it differential, is it to be apportioned, is it to be allocated?
Well, that's where you and I part company with respect. First instance, the mere existence of a loan was held to be a profit which could be accountable. And what Lord Legate is saying here in our submission is that that's not enough because you have to do the counterfactual. And it's only where the loan is at a beneficial rate as against a commercial loan that there's anything to account for. So if you have infringing activity which allows for a very advantageous director's loan, that difference, the key word is difference, that difference might generate a profit for the borrower. And he's saying that prima facie that would be accountable because it's advantageous as against the norm. That is an accountable profit.
How do you infringe trademark by following?
No, the act of infringement isn't the loan, my lord. The act of infringement is the sale of the goods. The sale of the goods generate an income, and that income makes available to the director a loan. So there is a chain of causation there. But what the point made by Lord Legate isn't about that chain of causation. He's cutting it off. Well, he's cutting it off at the end by saying, "Don't worry about the chain of causation. There isn't actually evidence of a profit here. We don't have to get into the chain of causation because there is no benefit as against a normal commercial loan." Let me put it another way. Assume the loan was the same one can get from Barclays on the high street. It's at 5.3% APR. There is no benefit to the defendants because they can access that as their non-infringing alternative. That is a common or garden loan. If the loan is interest-free for 20 years, that could be a relevant benefit. And one might then need to get in to investigate matters such as legal causation or remoteness. But Lord Legate doesn't need to get into that because he said on the evidence, you haven't actually got that differential. There are no differential profits. And in that context, could we move forward to 175, please? And could you please read paragraphs 175 and 176 to yourselves?
This looks overturned, doesn't it? I would comment in passing.
My lord, yes. There are 6 propositions we suggest one might usefully take from these paragraphs. First, there's approval for the approach of Justice Windayer in Colby and Palmer. We saw that was a differential profits case whose reasoning was itself based on Siddell and Vickers, and Cartier and Carlisle. Second, there's approval for the approach of Mr. Justice Slade in My Kind of Town, another differential profits case which followed Cartier and Carlisle. Third, the same principles apply to patents and trademark profits. Fourth, Lord Legate explains that the approach of my Lord Justice Lewison in the Abbott case was consistent with these principles. And if we look at the quote, we can see that. The point made in Abbott was that some customers insisted on infringing inserts, so-called, and others were happy with common or garden non-infringing inserts. And Lord Legate is embracing this quote because he's saying that a sale is driven by the infringement when the customer would not accept the alternative. They would not accept the NIA. In other words, for that customer, there was no NIA. They insisted on the patented solution. On the other hand, a sale is not so driven where the customer is indifferent and would have bought the non-infringing alternative. So Lord Legate here has equated the driving the sale test from Abbott with a counterfactual NIA analysis. Fifth, paragraph 176 is a direction for differential profits. The right approach in law is to ask what sales would have been made if the infringing sign had not been used. And sixth, and lastly, this reasoning anticipates a range of possible outcomes. And he says, whether it is likely that any, and if so, what proportion, in 176, that's important. Lord Legate anticipates that the counterfactual NIA sales might extend to some sales, or there might be none at all. The counterfactual might fail entirely because there were no indifferent customers. They all insisted on the trademarked goods, or they all insisted on infringing inserts or infringing power supplies. In such cases, all the profits would be attributable to the infringement. That is all in the context of and consistent with paragraph 156, which we looked at. Differential profits achieves the objective of putting the infringer back in their non-breach position. The court constructs the non-breach position, that's the counterfactual NIA, works out the difference against the real world, and orders the infringer to pay that difference. Before we move on, we should acknowledge that there were no remoteness issues here. We accept that legal causation remoteness still has a role to play after the differential profits isolation has been carried out. But it is not a broad allocative role. That is because the causation allocation has been accomplished by differential profits. The infringer has already been put in their non-breach position. My lords, the next stop is the Rukadze case.
Will you be coming back to that issue? Because at some point I would be grateful for more detailed explanation as to what you said, rather than what the causation is. Because at the moment I'm struggling with that because on your analysis so far, differential profit seems to cover almost the entirety of the terrain.
Well, I mean, we are coming. Round 2 is all about Anand Kasai and Neo.
But if we're going to come back to it in that context, fine.
Yes, but it's mainly about. I don't want to mislead my lord and promise some excitement that may not be forthcoming. It's mainly about the test for legal causation and less about what it accomplishes. But obviously, that is. That's in there a bit as well.
And I just, as I said, you don't need to give me an answer now.
Yeah.
I'm puzzled at the moment because on the one hand, you accept explicitly legal causation and remoteness still have a role to play after the profits.
Yes.
And yet I remain wholly unclear as to what you say that role is, because based on everything you've said so far, it seems non-existent.
All right. Well, actually, we're going to Rukadze next, where there is an example of the role played by legal causation remoteness in an account of profits, because there were the breaches of fiduciary duties. Lots of money was brought in. Some of that money was invested. Those investments yielded profits, and the defendants did not have to account for those profits because they were too remote from the breaches of fiduciary duties. We say that is a useful guide as to the role played by remoteness. But we will be coming on to see in some detail our criticisms of how the judge applied the remoteness filter under grounds 2 and 3. My lords, Rukadze is in authorities 4 behind tab 78.
Which?
78. It's the first tab.
Yeah.
If I can just summarise what was going on here. Case about fiduciary duties. The defendant had provided asset recovery services to the family of a deceased Georgian businessman through the claimant corporation and its predecessor. The individual defendants were partners and directors of the claimant corporations, and while they were still in those roles, they had disloyally disparaged the claimant corporations and taken over the provision of asset recovery services to the family on their own account, and they were ordered to account to their former businesses for the resulting profits. And in the Supreme Court, they sought to argue for differential profits in order to reduce their liability. Their case was they could, in the counterfactual, have resigned earlier and taken advantage of the same business opportunity with the family once they were no longer a part of the claimant businesses. They said they'd have made the same profits and that the law should recognise that counterfactual and allow for deduction of those profits. But the Supreme Court was unanimous that the appeal should be rejected, but the reasoning in the judgments varies significantly. The key difference is in the approach to liability. Lord Briggs gave the judgment of the majority, and he relied on the existence of the duty of a fiduciary to account. That duty was independent of any act of breach. So the account of profits described by Lord Briggs was not a remedy for a breach. Now one can immediately see that if one is not concerned with a remedy for breach, the differential profits approach is of no application. Differential profits is intended to isolate profits caused by a breach from those not so caused, and to put the party in breach back in their non-breach position. If there's no breach, there's no non-breach position. The whole analysis collapses. Lords Leggett and Burroughs took a different approach. They addressed the appeal on the breach basis upon which it had been argued, and they reached the same outcome. In particular, Lord Leggett identified the breach as being the misuse of information which the defendants had obtained in their roles as fiduciaries, and that allowed him to conduct a conventional causation analysis in the context of an account of profits. And for that reason, we say his judgment is of real assistance in relation to the issues before this court. But we start, please, with the reasoning of Lord Briggs, page 2377, paragraph 20. Lord Briggs makes the critical point about the fiduciary's duty to account. He explains there it's a duty which exists in its own right, not a remedy for the breach of some other duty. And thus, 3 lines up from the bottom, the wrong he identifies is no more or less than the failure to account. And then over the page, the final sentence of paragraph 20, he explains that there's no room for causation or remoteness or counterfactuals in these circumstances. And this is the context in which he explains at 21 that the fiduciary duty to account is nothing to do with an IP account of profits. In the IP context, he says, an account of profits is truly just a remedy. In other words, a remedy for breach. Moving forward, please, to 2388. Please note in passing that he dismisses the purported forensic difficulty in constructing counterfactuals, explaining that the courts have been doing that for 140 years. That's paragraph 56. And then over the page at 2390, paragraph 60, we find the passage that Astronics rely upon. Lord Briggs rejects the invitation to align the law's approach with that taken with equitable compensation. The reason he gives is that loss is irrelevant to an account of profits. They are chalk and cheese. We submit that in interpreting that reasoning, one needs to keep in mind what he said at paragraph 21, that the fiduciary duty to account is nothing to do with an IP account of profits, and his reasons for that distinction, that the former does not involve any act of breach. That is, we say, why paragraph 60 is of no application to an IP account of profits. Equitable compensation for a breach of trust, Lord Briggs's chalk, can follow common law causation principles, but enforcing a duty, fiduciary duty to account, the cheese cannot. Lord Legate, by contrast, embraces the breach analysis, and he explains that the counterfactual NIA comparison identifies with precision the consequences of the breach. It must follow that once that comparison has been carried out, the profits attributable to the breach have been isolated.
Where are you looking at?
So I'm just summarising, I'm
I
not
see.
reading, I'm making in advance to show you the passages my summary of what we're going to see. Because the NIA comparison identifies the consequences of the breach with precision, we say there is no conceptual room for the further broad allocation of profits carried out by the judge in this case. Could we start please at 2395, paragraph 85, where Lord Legate records the defendant's counterfactual case. In the second sentence, he says, had the defendants resigned before any preparatory and other disloyal steps were taken, they would still have provided recovery services and successfully negotiated a contract with the family to do so, just as in fact happened. Thus, all or almost all the profits which the defendants in fact earned would have been made even if there had been no breach of fiduciary duty. Then at 2398, paragraph 94, we see the origin of the divergence of approach as against Lord Briggs. Lord Legate has considered the profit rule from Snell's equity, and he says it's unhelpful because it mixes up the breach with the consequences of the breach. And he explains that profit per se is not wrongful. But that's not the position where the profit results from conduct, which is a breach of fiduciary duty. And over the following paragraphs, he explains what the relevant breach is here. So at 95, he introduces misuse of trust property. At 97, he says the three cases he's referred to, that's Keach and Sanford, Regal Hastings and Boardman and Phipps, extend the concept of trust property to information or business opportunities, and he develops that approach up to 104, where he unites information obtained by a fiduciary with misuse of intellectual property. So in the first 10 lines of 104, he considers an agent's misuse of a principal's information. And he says the same principle applies to the misuse of protected intellectual property. Could you read that passage at F, which starts the same principle to the end of the paragraph, please? And at paragraph 106, he says there's a common rationale in play. At the very bottom, the law cannot undo the infringer's wrongful acts, but it can do the next best thing of requiring A to surrender to P the benefits obtained by A from A's use, and in that way making it as if the wrong had not occurred. Could we move forward then, please, to 2412, paragraph 147. In the last sentence, he records the defendant's argument that there is no principled justification for applying different rules and tests of causation when the breach is of a fiduciary duty for those which apply elsewhere in the law of obligations, for example, when the breach is of a duty owed in contract or tort. And he addresses that in the specific context of an account of profits at 149. Would you please read that paragraph yourselves? The Lord Legate makes 2 points. First, he suggests that a common approach can be taken to determining what profits have been made as a result of breach of fiduciary duty and an act of IP rights infringement. Second, he suggests that a common approach can be taken to damages and profits. So the approach to causation of profits can be conceptually the same as the approach to causation of damages. My Lords, Lufthansa's appeal satisfies both those commonalities. We say the position Astronics urged upon Mr. Justice Leach, and which he follows, satisfies neither. It involves first differential profits and second a broad allocation. And that regime is, as far as we are aware, without precedent in accounts of profits in any jurisdiction for any cause of action. Lord Legate comes on to consider the role of the counterfactuals at page 2415, paragraph 160. And then paragraph 162 is about damages and counterfactuals. Could you read that, please? The purpose of the comparison is to identify with precision those consequences of the defendant's conduct for which the defendant should be held responsible. And then at 163, he sets out the procedure. First, identify.
Before you go on,
Yes.
do you have anything to say about parenthesis in that last sentence? Subject to any further limiting factor.
Yes, absolutely. And the principal limiting factor would be legal causation remoteness. I don't shrink from that at all.
Sorry, again.
Yes, so and then 163, we see the procedure, which involves first identifying the duty, and second, construct a hypothetical scenario in which the defendant's conduct is changed to the minimum extent necessary to achieve compliance with the duty. That's the NIA. Then at 170, Lord Legate explains that the same conceptual approach should be taken towards profits. Could you read that to yourselves, please, my lords? He says that differential profits identifies with precision the consequences of a breach of duty. Quite so, we say. In our case, when Mr. Justice Leach carried out the differential profits analysis, he identified with precision the profits derived from the defendant's acts of patent infringement. Lord Legate then explains how this symmetry is supported by the Supreme Court decision in AIB group. Forward then, if we can, to 2425. In paragraph 200, we decide that the right approach to determining whether profit resulted from a breach of financial fiduciary duty is to ask whether that profit would have been made if no breach had occurred. That's differential profits. And over the following paragraphs, he points out the error in the defendant's argument. They said we could have resigned earlier, and he explains that that is not a non-breach counterfactual. 201, para 201, he effectively identifies the correct counterfactual, and that is one in which the defendants did not exploit the business opportunity which they had come across while working for the claimant, and made no use of the confidential information they received in those roles. Then forward to 206, please. Second sentence, he says, I pointed out earlier that to isolate what difference the defendant's wrongful conduct has made, it's necessary first to identify the conduct which constituted a breach of duty and then construct a hypothetical scenario in which the defendant's conduct is changed to the minimum extent necessary to achieve compliance with that duty. That's differential profits. Here, that scenario is one in which the defendants resigned from their positions with the claimants, but did not take any steps to exploit the opportunity to provide the recovery services themselves. And he says that no profits are achieved in that correct counterfactual scenario. The correct counterfactual is not one in which the defendants simply sat on their hands. They were permitted to assert a counterfactual course of action, and that included resigning earlier than they had done in the real world. But what they could not do was continue to rely on the benefits of any act of breach. And without any act of breach, they would have accrued no profits whatsoever. My lords, we can move forward then to Lord Burrows, who takes a similar approach to Lord Leggett. At page 2440, he says 258 that the dispute could be approached on the basis of the duty to account, in effect Lord Briggs' position. But he says it can also be considered on the basis of the remedy for a breach basis. That's the one addressed by Lord Leggett. He says it's important to take the second course because that was how the appeal was argued. That's at 261. And to see whether it leads, this is at the end of 261, whether it leads to the application of a but-for causation test, including the lawful alternative counterfactual. The lawful alternative counterfactual is the NIA. Then at 266, he records the appellant's submissions about the need for a causal link, and that the right causal link involves consideration of counterfactual non-breach profits. That's the NIA again. And then the last sentence is important. The starting point identifies the pool of profits, and there may then be a further cutback because some of those profits may be too indirectly connected with, i.e. too remote from, the breach of fiduciary duty. Again, I think that answers my Lord Justice Arnold's question about where we say remoteness fits in here. It is a subsequent filter after the factual causation differential profits step. That is the approach we urge on this court, a mirror image of damages as also proposed by Lord Legate. So differential profits are subject to a cutback where some profits are too remote from the acts of infringement, but there is here no consideration of a second isolation stage, an allocation stage, because all the profit isolation work is done by differential profits. Now, Lord Burroughs then explains how, as a matter of authority, the approach taken to fiduciaries' duty of profits has not followed that course. So at 270, he says that there is no consideration of the profits which the defendant counterfactually, this is the end of the paragraph, counterfactually might have lawfully obtained. In that sense, the but-for test is not being applied. And at 272, he says there are other fields where the NIA counterfactual has been rejected. He identifies Celanese. So for present purposes, we invite you to note that Lord Burroughs considers that Mr. Justice Laddie rejected the NIA counterfactual, took a different approach, and that led to him apportioning profits, as we can see in the passage between G and H. Paragraph 274 over the page is then important for our purposes. Lord Burroughs recognises in terms that Siddell and Vickers and lifestyle equities are at odds with Celanese. They are cases indicating the converse. They indicate that the court should compare the profits actually made with those that would have been made if the next most likely means of non-infringing manufacture had been adopted. And he then rightly equates them to the approach in lifestyle equities, and he quotes paragraph 176 of lifestyle, which we just looked at. So in these passages, Lord Burroughs articulates the foundation of our first ground of appeal. Whether Celanese is right or wrong, it's taking an alternative path to differential profits. The judge had to choose one or the other, and not both. If I can summarise then where we say we are in light of Rucata, we accept that the judgments of Lords Legate and Burroughs are not binding on this court, but they are highly persuasive. They are of both direct and indirect persuasive effect. As a matter of direct effect, they decide that differential profits is a principled method for isolating precisely the profits derived from acts of patent infringement. They also make clear that an award of all profits is a legitimate outcome for a differential profits analysis where the counterfactual NIA is not profit bearing. As a matter of indirect effect, you're told that Celanese takes a converse approach to lifestyle equities and Siddell and Vickers by excluding any consideration of NIAs. And in that context, we've seen the reasoning in lifestyle equities expressly addresses profits for patent infringement. My lords, those are the authorities I rely on the first approach, and I was going to go next to Celanese and explain our position in relation to that authority in light of the reasoning we've been looking at. So Celanese is in authorities 1 behind behind tab 32. As we've just seen from Lord Burroughs, in Celanese, Justice Laddie rejects differential profits. Just to put you in the procedural picture, that rejection is based primarily on the rule in United Horseshoe. Before the judge, we said that the rule in United Horseshoe was bad law and that Celanese was wrongly decided. And before the judge, Astronics agreed.
Sorry, you said United Horseshoe is bad law?
Yes.
Did we say that? A House of
Yes,
Lords decision?
Well, it's not a profits case, it's a damages
No, of that I
case.
follow. You may say it's distinguishable, but can we say it's bad law?
It's also a Scottish case.
Make it bad.
Well, so we don't. No, it doesn't make it bad law. Sorry. What? Let me rephrase that. What has been taken to be the rule in United Horseshoe doesn't actually come out of the judgment in United Horseshoe. What has been taken to be the rule emerged in the 1980s, I believe, in a judgment of Mr. Justice Faulkner. But if you go back, this isn't going to arise on this appeal, but if you actually go back through the judgments, and in particular Lord Adam in the Court of Appeal, the problem was that the law of validity at the time had a requirement for utility. If you had a patent which was valid, it had to be useful. And the defendants had admitted that the patent was valid. They didn't challenge validity. There was a stipulation that it was valid and therefore useful. And when it came to the damages inquiry, they wanted to say, this patent's nonsense, it's rubbish. We actually made more money when we disconnected the infringing apparatus. Lord Adams said, we can't do that because you've admitted it's useful. You're now saying it's not useful. And it's my submission, that's where all the difficulty came from. There was this conflict between the admission at first instance and then an attempt to say, when it came to admission in the context of validity, and then an attempt to sort of grow back on that in relation to damages. Anyway, at first instance in this case, we said that what has been taken to be the rule was bad in law, that Celanese was wrongly decided, and that was all common ground. The extent to which it remains common ground in this court is unclear to those of us on this side, but there is no respondent's notice in relation to it. I can tell you that my learned friends describe this judgment of Mr. Justice Laddie as magisterial in their skeleton argument, which is difficult to reconcile with their concession that it was wrongly decided, but we'll see where we get to it. Could we start, please, at 672 with BP's argument? BP was the defendant and held to have infringed. Paragraph 16 at line 14, BP said that profits derived from infringement can be assessed properly in one of two ways. The first is called differential profit or incremental profits, and the second is called an apportionment. BP said the incremental approach was more accurate, and at paragraph 17, the judge sets out some of the evidence of Mr. Richard Bolton to that end. In paragraph 20, we can see that in support of differential profits, BP relied on Siddell and Vickers, My Kind of Town and Seoul, and the Canadian appeal case, Imperial Oil and Lubrizol. Celanese's position is sort of set out at from 25 to 30, they resisted any deductions at all. And first sentence of 27, although it's not stated to be so, they relied on the rule, it's not attributed rather, they relied on what is taken to be the rule in United Horseshoe. So the first sentence of 27. In relation to damages, it's not permissible to say by way of defence that the defendant could have taken an alternative course which would have inflicted the same or similar damage. That is what the rule in Horseshoe has been taken to be. It is improper to assert a counterfactual non-infringing alternative. And then moving forward to 31, the heading there is incremental versus apportionment approaches. The judge is setting this up as a decision between two approaches for isolating profits, and we say he was obviously right to do so. He starts by saying they're not alternative ways to reach the same figure. Again, that's right because they are conceptually distinct approaches. And if we can move forward to paragraph 35, general principles. Mr. Justice Laddie starts with damages. And at line 45, he says, in working out quantum, the court has to determine what acts of infringement have been committed and what damage has been caused in the legal sense by them. In doing this, the court is not allowed to speculate on whether the defendant could have avoided infringement, and if so, what damage would have been inflicted. Firstly, note there the correct reference to damage caused by infringing acts. We consider that, given the date of this judgment, that the reference to causation there is a compendious reference to what we would now call factual and legal causation. But that sentence about the court is not allowed to speculate is, in our submission, the start of the problem with Celanese. That rule of law is attributed to Mr. Justice Jacob, as he then was in Gerber and Electra. That's line 5, page 679. And in Gerber, it is attributed to the rule in United Horseshoe.
Well, I can't. Well, just tell me what's wrong with what Mr. Justice Laddie says there.
In endorsing the rule in United Horseshoe.
Well, in saying, if you have infringed,
Yes.
if you have committed a tort, and as a result of your commission of the tort, a person has suffered an injury, you can't say, well, if I hadn't committed the tort, you would have suffered the injury anyway.
The answer, my lord, is while that is intuitively appealing, it is wrong as a matter of causation of loss. Well, you can take that route, as Lord Burroughs explained, in particular circumstances. As a matter of policy, you might have a policy for over-rewarding patentees, which is effectively what the rule in United Horseshoe is. It is a policy for saying, I don't care whether you've got a good patent or not. I'm going to hit you hard with a damages award, or I'm going to hit you hard with a profits award, even if the patent could easily have been avoided. I'm not going to take any notice of the real value of the patent, of its market power, because we've got a policy that says infringers have to pay through the nose. The reason it's wrong is people think it's a denial of liability. It's not. You accept liability. You're now at the second stage. What's the damage that has flown from that act as opposed to from something else?
Why, as opposed to from something else? Take the facts of Horseshoe. The plaintiff who had the patent was selling nails. The defendant who infringed the patent sold nails which infringed the plaintiff's patent. The evidence was the plaintiff's sales went down. The House of Lords accepted that the plaintiff's sales went down because the defendant was selling its infringing nails. What they said was, it doesn't matter. They could have sold non-infringing nails. The fact is they did sell infringing nails, that did damage the plaintiff. What's wrong with that line of reasoning?
The problem is this. Let's assume the facts were as the defendant said. Let us assume that, so one of the patents was for a machine which deblanked the nails, it popped them out, and they tried it, and they said, actually, we made more nails when we took it off, but it was broken. We've got the numbers. When the machine was broken, we were more profitable. Because the patent wasn't of any value.
But it may or may not have been of value in that sense, in the sense that you could have made better, cheaper nails in a non-infringing fashion. But they didn't. I mean, as a matter of fact, they accepted they had used the plaintiff's invention to make their nails and then sold them.
So but there is one is not saying anything to gainsay the liability finding by then saying at the quantum stage, well, now we're here to actually value the patent. How do we do that?
You're not valuing the patent, you're valuing the impact on the plaintiff's business of what the defendant has been found or admitted to have done that was a tort.
Indeed. And I accept completely that it is a policy decision whether in that valuation one allows for the counterfactual non-infringing alternative or one does not.
Why do you say it's a policy decision? Why don't you just say it's a question of fact? That's what I'm having difficulty with.
Because the law of causation of loss, as we've seen from all the authorities we've looked at this morning, typically allows for the erection of a counterfactual for the purposes of identifying the loss which should, as a matter of policy, be attributed to the breach as opposed to anything else.
But the counterfactual which the House of Lords in effect accepted in the nail case was that you didn't sell nails, not that you sold other nails. That's what they said. We're not taking account of the fact that you might have sold other nails. The fact is you sold infringing nails. The counterfactual for that is you didn't sell those infringing nails.
So if that had been exclusively a finding of fact, I've got no difficulty with it at all. The difficulty we have with the rule in Horseshoe is in saying, as a matter of policy, a defendant is not allowed to advance that argument. So let me give you another example which I've relied on in a different case. One has a service station in the middle of nowhere, and there are two types of petrol being sold. One is high octane and one is normal petrol. And this service station has excellent records over many years, and it shows that whenever they don't have the high octane fuel, when they put the hat on the pump, all those sales become sales of the standard fuel. Overall, they send precisely the same number of litres of fuel. Turns out that unbeknownst to them, there's a patent for the high octane fuel, and they get sued for damages. And they say, and the patentee says, we've lost sales of our high octane fuel from our other service stations, even though they're hundreds of miles away. The defendant says, well, no, you haven't, because we know precisely what happens when we don't sell the infringing fuel. We just sell more of the other one. And actually, the patent makes no odds whatsoever. And the rule in Horseshoe says, you're not allowed to say that. I mean, it may be true as a fact, maybe your evidence is overwhelming, but as a matter of policy, you are not allowed to say we would have sold the non-infringing fuel.
No, but you are allowed to say, on the evidence, whether we sold your high octane fuel or not made no difference to your sales of high octane fuel.
Well, but you can't make that good when the question is, well, who makes those sales? You can't say it's us on the other pump. You cannot assert that non-infringing counterfactual. And it's an absurdity. If we move that second pump to a third party across the road, And if the evidence still shows that when the hat is on the infringing pump, everybody buys, or maybe on the same side of the road, 100 yards down, everybody buys fuel from the second service station, which is owned by a third party, the defendant is allowed to say, you haven't suffered any loss because all the sales go to the third party. It is a policy decision which restricts the evidence, which restricts the assertions which the defendant is allowed to advance in defence of a damages claim. It has been distinguished repeatedly. It has been overturned in the Supreme Court in Canada. It has been excluded by all the authorities. It's in conflict with all the authorities we looked at this morning. Not one of them, with the exception of breach of fiduciary duty as considered by Lord Burrows, accepts this fetter on a defendant's position because it systematically results in the over-rewarding of claimants. And it was common ground at trial that it was not to be followed. The judge described that as a concession. So at paragraph 37, my lords, back in Celanese, the judge moves on to profits, and he says that profits and damages proceed on a common principle of legal causation. Again, we think he means causation in the round, factual and legal together, in effect the meaning of derived from the infringement in section 61(1)(d) of the Patents Act. And he's in agreement with Lord Legate here about the symmetry between damages and profits. And at 39, he says that as a result of these common principles, there should be no answer to an account that the defendant could have made the same profits by following an alternative non-infringing course. So he's extending the rule in United Horseshoe to profits. But as we can see, BP resisted this by relying on three authorities, two of which we've looked at already. And he says this rejection of differential profits is supported by the Peter Pan case and the Federal Court of Appeal in Canada in Baker Energy and Reading and Bates. Now, as to the Peter Pan case, we consider the position is equivocal. Mr. Justice Pennyquick found that without the claimant's confidential information, the defendants could not have manufactured their products at all, and he made an award of all the defendants' products. On the other hand, the report acknowledges that there were other types of padded brassieres on the market. We suggest that the decision is not a clear authority either for or against consideration of an NIN. As for Baker Energy, this reveals another inconsistency in Astronics' position. At the same time as lauding the Celanese judgment, they caution against any association with the course taken in Canada, which they call a homegrown approach to accounts of profits in patent cases. We say, well, we can't really have it both ways. Mr. Justice Laddie relied on two Canadian Federal Court of Appeal cases. He recognised correctly that the same issues about causation and remoteness have been debated in Canada, and that there was value in the reasoning of the senior Canadian courts in resolving them. Canadian authority now points unequivocally in the opposite direction. At this stage, let me just interpose the key passage from the Canadian Supreme Court in Monsanto and Schmeiser. I don't think you need to turn it up, but for your notes, it's at JA4, tab 82, paragraphs, page 2551, where they say this: the preferred means of calculating and accounting of profits is what has been termed the value-based or differential profit approach. where profits are allocated according to the value contributed to the defendant's wares by the patent. There is then a reference to the Seabrass article we looked at, and they continue. A comparison is to be made between the defendant's profit attributable to the invention and his profit had he used the best non-infringing option. So directly contrary to the approach we see in Celanese, entirely consistent with Lord Leggatt in Lifestyle Equities and Lufthansa. Back in Celanese at paragraph 41, Mr. Justice Valley gives an example which he relies on in support of his allocation approach. For your information, that example is comprehensively debunked by Professor Seabrass at JA4, tab 91, page 3086. I don't think we need to go there, because there's another example at paragraph 58, which is a little more useful. So this is paragraph 58 on page 686. At line 20, the judge said this: an article is made by use of a standard process involving 5 steps. Each article is sold at a price which realises a profit of £1,000 on the assumption that each of the steps is similar in cost and there is no obvious reason to distinguish between them. It would be fair to attribute £200 of the total profit to each step. Assume now that one of the steps is replaced by an alternate patented step, which affects no appreciable change in the end product, nor difference in costs on sale price. The same £1,000 profit is made. It would be fair and reasonable on account to say that the patented step, just like the one it replaced, was responsible for £200 for profit. On the taking of an account, it is that figure which would be payable by the defendant. As a matter of economic logic, we say that analysis is fundamentally wrong. The patented step has replaced a standard step which was openly available on the market, and it has conveyed no advantage whatsoever over that prior art step. That patent has 0 economic value and has made no economic contribution to the resulting profits. No rational business person would pay £1 to license that invention because no profit can be derived from its use.
I mean, when I read that, I thought that sounded right. Can I pick up my Lord's example of a ransom strip and adapt it in this one? There's a development site. There are 2 possible ways of getting to it. The developer could have, and the evidence is could quite cheaply have, accessed his development over land belonging to A, but he chooses to access it over land belonging to B without B's consent. So it's a trespass. Is it any answer to a claim for damages by B for trespass to say, oh, but I didn't need to go through your land, I could have gone through someone else's land and it wouldn't have cost me anything?
So it's not an answer to the claim to trespass, so that's established. The market value of that access was nothing. The market value was set by the price of the alternative.
So you wouldn't pay any substantial damages at all, even though you have actually taken and used the claimant's property, and in circumstances where it's just a wrong.
Well, my lord, if we're talking about licence fee damages, so we're not talking about damage to the property itself or displaced economic activity, but licence fee damages, that is already the state of the law. So in the context of licence fee damages, the rule in United Horseshoe has been held to be inapplicable. That's the 32 Red case, or rather there's a host of cases.
So it's a defence to a claim for damages for taking and using your property, but I could have taken and used someone else's property instead.
So I slightly quibble with the term a defence to a claim for damages. It is better, I respectfully suggest, to say it is relevant to the valuation of damage. When you are valuing the quantum, it is relevant to consider what non-infringing alternatives were available, because that informs that is how one best isolates the damage caused by the breach in issue.
In a classic example, if I take your horse and take it for a ride, it may do the horse no damage, may do the horse good,
Yes,
but I still have to pay because I've used your horse.
yes, you do.
But on your case, if I had my own horse sitting in a stable, which I could have used instead, but I chose to use yours, I wouldn't have to pay you any damages. Is that right?
No, that's not right.
Why not?
So because the use of so the license fee damages in those circumstances are set by the market rate for the right that you used. The market rate doesn't take account of your own facilities. The market rate is the rate for renting a horse. That is the license fee that you are deemed to have foregone. That is what you have to make. That's what you have to pay to the owner of the horse. So it's not an answer just to say. It doesn't give you free rein to say, well, I could have done this subjectively. The question is, what is available to you in the marketplace to so as to isolate the consequence of the breach in question. It is a tool for the isolation of damages or profits by reference to the infringement that one is dealing with.
You started this submission by saying it was relevant to look at the NIA. Is it essential to look at the NIA or merely relevant?
I'm not quite following that question. The proposition is that the defendant is entitled to assert a non-infringing alternative course of action for the purposes of isolating the financial consequences of a breach.
And if he doesn't?
So if he's unable to, or if he chooses
Not to, let's say.
well, it may come to the same thing. That may be a matter of the procedure adopted in a particular case. And he may say, the defendant may argue that this is not the right route, this is not the applicable approach on the facts of this case. And the court may disagree, because the court may take the view that it is the preferred route and it is applicable, in which case declining to advance any NIA argument would be risky. But it's not, as I said, there is always an NIA available, it's just not doing the act at all. This is an option for defendants to advance a case for the purposes of the isolation exercise. But not advancing one or failing in the case that one advances doesn't defeat the exercise. What it establishes is that the right was of dominant value. There was either no route to that market without infringing, or any other route was less profitable. Can I invite, to the extent that my lords are interested, further explanations of the errors that we see in this passage that we've just been looking at are explained with some care by Professor Cotter. That's JA4, tab 93, page 3202, and Professor Seabrass at JA4, tab 91, page 3103. There is, we suggest, in this passage, a demonstration of the danger in replacing a structured, economically rational approach with more nebulous concepts such as fairness and reasonableness. Now, the second half of the example actually identifies the right approach but then mixes it in with the wrong one. In the second half, the judge says this: now consider a case where the replacement patented step makes no substantial alteration to the end product, which is sold for the same price, but introduces efficiencies such that the profit per item increases by £50 to £1,050. In such a case, the court might fairly conclude that the profits attributable to the invention are £250, that's the original 200 with the increase of 50. It can be said that the initial apportionment gives rise to a base allocated profit of £200. The incremental approach demonstrates a differential profit of £50. The differential part of that analysis is correct. The patent makes available £50 worth of savings. The patent has caused £50 worth of profits. But this is effectively a reference to a counterfactual non-infringing alternative. This is the judge here is doing that which he has said is impermissible. The counterfactual non-infringing alternative process costs £50 more to use. The economic value of that invention is precisely £50 per item. That is the contribution that it makes to the profit. My lords, the last thing we need to look at in Celanese is the treatment of the authorities relied on by BP. And that starts at paragraph 63 with Imperial Oil and Lubrizol in the Canadian Federal Court of Appeal. Mr. Justice Laddie held that Lubrizol strongly supports apportionment as opposed to differential profits. In Nova and Dow, the Canadian Supreme Court reviewed Lubrizol and came to precisely the opposite conclusion. They actually quoted the same passage. Perhaps we could just turn that up quickly. JA4, tab 90, page 3006.
Page
3006. And at 57, they say the Federal Court of Appeal in Imperial Oil did not have the benefit of Monsanto and Schmeiser. However, its reasoning accords with that in Schmeiser. To isolate the profits causally attributable to the invention from the profits attributable to non-inventive features of the infringing product, the court would compare the infringer's profits from the infringing product with what they would have earned with a non-infringing option, motor oil without the patented additive. We can put that away, and back in Celanese, next, at 64, Mr. Justice Laddie says that My Kind of Town and Sol does not support differential profits. Well, as we saw, Lord Leggett has taken a different view in lifestyle equities. We suggest that the error that Laddie J has made is in overlooking the approach that Mr. Justice Slade extracted from Sir John Romilly and Carlyle and Cartier. Then Mr. Justice Laddie looks at Siddell and Vickers. He accepts that the per curiam statement supports differential profits, but having looked at it more closely, he says the position is unclear. And as we've seen, that's contrary to the view that Mr. Justice Windayer took in Colby Palmer, contrary to the view of the authors of Frost on patents, but perhaps most significantly contrary to the view of Lord Burrows in Rukadze. My lords, it's apparent from the passages we've been looking at that Mr. Justice Laddie treats differential profits and apportionment as alternative solutions to the same problem. And we can see that when he ends his review at paragraph 72. Having distinguished the cases, he decides to accept Celanese's preference for apportionment and to reject BP's differential profits approach. That proposition is also confirmed by Justice Cote in the Supreme Court in Canadian Supreme Court in Nova and Dow. She dissented in relation to an issue which that we may have to come back to. That issue was whether the defendant's NIA had to be a competing product or not. But again, I don't think we need to turn it up, but the reference is JA4, tab 90, page 3035, paragraph 166. She said, Mr. Justice Laddie and Celanese described two approaches, the incremental or differential profit approach and the apportionment approach. She then quotes how each works and says, Laddie J expressly rejected the differential profit approach in favour of apportionment. Next was the Abbott case, which we addressed in some detail in our written submission, paragraph 30 to 41. And we explain there how my Lord Justice Lewison's judgment can be interpreted consistently with differential profits. And as we've seen, that was the view of Lord Leggett in Lifestyle Equities. At the same time, however, your judgment includes two quotations which effectively paraphrase the rule in United Horseshoe, paragraphs 19 and 26.
Which tab?
So that is JA2, tab 47. So under paragraph 19, you quote the meters and metropolitan gas meters case, in the middle of the quotation, about 7 lines down, it is no answer to the plaintiffs whose invention has been infringed to say that similar results could have been achieved without infringing the patent.
Yes, so that was a damages case.
Yes, indeed. And then at 36, 26.
So I make that point at paragraph 20.
And then 26 in the context of the account of profits, you quote from Celanese to the same effect.
Yes.
My lords, given that it's common ground that the rule in Horseshoe should not be followed, in our submission, Abbott is of no direct assistance, but in any event, there is no support in Abbott for the double deduction approach, which is the subject of our first ground of appeal. So we come then to double deduction in the judgment. We are done with the authorities. We argued before the judge for differential profits, followed by conventional legal causation remotes. We recognised that Lufthansa's convoy goods case, the profits on the non-infringing supply of secondary components raised remoteness issues. And we accepted that remoteness operates to cut the chain of causation where it extended so far from an infringing act that the act was no longer a proximate cause of profit. But we argued on the fact that the profits of secondary components were not so remote from the supply of primary components. Astronics, by contrast, argued for a much broader application of legal causation. They said it permitted the double deduction. First stage, differential profits. Second stage, a broad allocation as one sees in Celanese. Our response was to say that that was contrary to all the authorities, which explained that these, well, firstly, the authorities which explained that differential profits achieves a profit isolation objective, and that it was contrary to Celanese itself, which also treats these as two alternatives. The judge does not appear to have addressed those arguments directly. Instead, he resolves the dispute by reference to the judgment of my Lord Justice Arnold in Anand Kasai and Neo. In effect, he held that according to Neo, legal causation operated as a gateway to his second deduction, the broad allocation of profit. We will be coming to Neo in detail when we come to the second ground of appeal after a short adjournment. For present purposes, we simply submit that this was not an answer to our arguments. The issue of double deduction doesn't come up in Neo, just like it didn't come up in Abbott. Indeed, it's not addressed in any authority, because no one has ever, to our knowledge, argued for it before. Although he didn't address the argument, there are parts of his reasoning which bear on the answer. So if you have the judgment under appeal, which is in a confidential bundle, tab 1, if you turn please to page 320, this is in the context of his decision on how to carry out the second stage allocation and his decision to adopt a licensing approach. He says at 573 that there is nothing in lifestyle equities which prohibits that. And then picking it up 5 lines down, he says, but in any event, the purpose of both the differential profits analysis or an apportionment analysis is to put the infringer back in the same position financially as if no infringement had taken place, by attempting to isolate or identify those profits which were caused by the infringement. That's entirely correct. But if both approaches have the same objective, it is wrong in principle to use first one and then the other. You can choose between them. You don't do both in series. Now please look at the prior paragraph. Mr. Bezant was the forensic expert for the defendants. Mr. Bezant also accepted that the differential profits approach is to be preferred, and that no apportionment may even be necessary where the profits derived from the infringement can be isolated perfectly. Again, I agree. Where it's clear that either all of the profits made by the infringer from a complex product or a specific proportion of them can be attributed solely to the infringement of the patent, then the court will adopt the differential profits approach to apportionment. But that is not this case. So what he's done is he's carried out a differential profits analysis whose objective he accepts is to put the infringer back in the non-breach position. He's then decided that it hasn't worked satisfactorily because it's not clear that all the differential profits can be attributed to infringement. That is a category error. he's added an additional step where the judge acts as gatekeeper to the approved method for profit isolation.
Well, can I just ask you this question about that? Your argument, as I understand it, you may resist this characterisation, is that it is wrong in principle to apply two different approaches sequentially to answer the same question of factual causation. But the counter-argument advanced by the respondents is that that's not what the judge did. What he did was first to determine factual causation using differential profits, and secondly, to apply legal causation using...
Yes, my lord has the battle lines drawn correctly. But what I say about that is, as we've seen from everything we've been looking at this morning, is that that sequential approach, by relegating apportionment to legal causation remoteness, is without any authoritative support. We see apportionment as the route down which Mr. Justice Laddie had to go in Celanese because he rejected differential profits. They are both, because they are both doing the same job, you can't, as a matter of economics, do one and then the other because you are doing a double stage isolation. You need a different...
In the course of the working out of an equitable remedy, the overall purpose is to make the infringer pay what is justly yours and let the infringer keep what is justly theirs, which is the way Mr. Justice Slade described it in My Kind of Town. That's the overall object of the exercise, isn't it?
We would prefer to do it by reference to Lord Leggett in Lifestyle Equities. The overall objective is to put the infringer back in their non-breach position with an asterisk. The asterisk being that carrying that out must be done subject to remoteness. So, in answer to my Lord Justice Arnold's question, it is fundamental to our ground one of appeal that these two are alternatives to the same objective. Because when you've done one, you have isolated the profits factually caused by the infringement. You're there. You don't then say, well, I'm going to do another one which serves the same purpose.
Well, indeed, but you've run 572, which prompted the question, because what he goes on to say is, I found the infringement was not the legal or proximate cause of defendant's profits. So he's explicitly, as it seems to me, in that paragraph, I don't think it's the only paragraph, using apportionment as a tool for addressing the question of legal causation, not the question of factual causation.
My Lord is entirely correct, and that is the subject of our second and third grounds of appeal. And of course, they're all related. But just to be clear at this juncture, in the world of apportionment cases, you do not see anyone else saying, this is remoteness. I'm doing apportionment now to give effect to remoteness. The first time you see that is in this judgment. What you see in apportionment cases is, in effect, what my Lord Justice Lewison says to me. Let's look at it all in the round. What's a fair, reasonable amount to award? I'm unconstrained by anything. I can do it by reference to cost or colour or the birthday of the infringer. It doesn't matter because it's all very loose and equitable. But the structured approach, which is that set out by Lord Leggett in the two Supreme Court cases we have looked at, doesn't allow for that sort of impressionist discretionary award. It asks, what was the cause in fact, according to conventional causation principles, and then are any of those losses or profits still remote? My lords, I wonder if that's a convenient moment.
Yes, thank you very much.
All right, vehicle